Confused about U.S. immigration? Or unsure which path is right for you? At Raju Law, we guide individuals, families, and businesses through complex U.S. immigration matters with clarity and confidence. Led by attorney Raju Mahajan, our experienced immigration attorneys share practical insights, real solutions, and up-to-date guidance you can rely on. Join our free online session every Monday at 11 a.m. Eastern Standard Time, where our attorneys discuss key immigration topics and answer your questions live.
Hello everyone, and warm welcome to Rajulo's Monday Live. I am Ms. Dushari Turin, and I'll be your host for this session. Today's topic is especially important for investors and families exploring the EB-5 Immigrant Investors Program. The 2026 deadline, why now is the critical window for EB-5 investors? A quick heads up for all the viewers, we will be sharing our weekly immigration news update at the end of the session. So be sure to stay with us till the very end. To guide us through today's discussion, we are joined by an exceptional guest, Chelsea Smith, supervising attorney of Raju Law. Ms. Smith, it's wonderful to have you with us today. How are you doing?
I'm doing well. Thank you for having me today.
That's great to hear. Our audience, I'm doing very good. Thank you for asking. Our audience is very eager to understand the EB-5 timeline and what the 2026 deadline really means.
Excellent.
Please go ahead.
Okay, let's see. Can you see my slides?
At the moment, I can see you though. Yeah, I can see you now.
Perfect. Well, thank you for joining me today. I am excited to talk to you about the EB-5 visa. This is an investor business classification visa. We are going to be discussing more of timing and that kind of aspect of the strategy as opposed to qualification and components of that visa petition. So today we are going to focus specifically on the September 30th grandfathering clause. There are temporary fee rollbacks and strategies to avoid the retrogression. Within the EB-5 Reform and Integrity Act, referred to as RIA, there is an authorization for regional center program through September 30th of 2027. So what many people thought is that they could apply through September 30th, 2027. However, there is a grandfathering protection that expires 1 year early on September 30th, 2026. This is something that many people overlooked or didn't realize initially about this act, about this law that's in place. So what does this mean? Well, this means that if you file before September 30th, 2026, your petition will be legally protected through this statute, even if Congress fails to renew the program in 2027. This requires the USCIS to continue processing your case. For those of you who may be familiar with the 2021 lapse, this is kind of similar we saw in the past where the statute lapsed, it didn't get renewed, but the USCIS must continue processing cases that were filed before that specific date. If you were to file after September 30th, 2026, you certainly can. However, you will not have the statutory protection of the program if it lapses in 2027. This could cause your case to freeze indefinitely or be paused, and there wouldn't be any kind of statutory protection that you could lean on to have your case move forward. So the big takeaway today is going to be that filing early 2026, it could give you statutory protection in the form of what we call insurance. If we were to face a situation where the statute isn't extended or there's some kind of political dysfunction that causes the the statute to lapse permanently, right? Or temporarily even. The other thing that we wanted to talk about is this fee reset window. In addition to the RIA clause, what we are seeing that in Moody v. Macoris, in late 2025, the USCIS fee hikes, they were temporarily revoked. That doesn't mean that they were revoked permanently, though. It's temporary. That means that they will resume at a later date. So we currently see that there could be significant savings for EB-5 applicants. Currently, the fee structure requires the $33,675 plus the integrity fund fee. Previously, it was up over $11,000. And what we see right now is that it could be a $7,000 to $8,000 savings per investor. So that's a pretty significant savings in terms of this application. And you could also, by seeking the protections of the RIA statute, filing before September 26th, September 30th, 2026, you could also have a fee savings for application under the protection of the recent court ruling from late 2025. So the urgency in this matter relates to the fact that this is a temporary injunction. That means that the USCIS is actively preparing a new and final rule, and we expect that to come to us later this year, possibly Q3, Q4. So the strategy that we propose is to go ahead and file so that you can get that statutory protection in addition to the temporary fee rollbacks. Those would be two advantages to going ahead and filing now if you are eligible to do so. And the third benefit to filing, and why we believe now is a great time to file for the EB-5, is because there's currently this opportunity with the visa bulletin being current in all countries, including India and China, which is unusual. They can be very difficult pathways, and currently the EB-5 is a pathway where the visa bulletin is current, which is, very great for anyone who has ever looked into where the visa retrogrades could be. Sometimes they can be upward of 10 plus years. So one thing that is mentionable is that there are reserved categories, meaning that they're set aside with priority for rural and high unemployment and infrastructure. Those are key areas. If you're planning to contribute to those, then there is reserved categories or set aside priority with that. So while the visa bulletin is currently up to date, it's present, there is a real risk of retrograde as this visa becomes more known, as the statutory interpretation becomes more understood, and people realize that September 30th of this year versus next year is that grandfather timeline. The risk of retrograde becomes very significant. Think of it as a supply demand. So as the demand surges, you will see that they fill up their visa quota much more quickly, and then that runs the risk of having a backlog or a retrograde. Our prediction is that the retrogression of high unemployment areas will be satisfied by late 2026. We think that currently the advantage would be for rural. Those people are seeing processing much more quickly. They're seeing less applicants for those areas. And we've provided for you today a short filing strategy checklist. Now, this doesn't necessarily show you that you are eligible, but what it does is give you some things to think about if you are considering this, contemplating this, maybe even for the first time. One thing that we need to be able to do is provide a source of funds. We would want to start immediately. we would want to make sure that we are ultimately able to meet this September 30th deadline. We really want you to start this source of funds process by, like the May-June timeline. You can see that what we run into here, and I have an additional slide for timing. What is the recommended timeline if you think you want to start? And I'll get to that in my later slide. But this part is sometimes where where it takes the most time to gain access to your source of funds. And to document your source of funds. So what we want to do is we want to make sure there's adequate timing for this, because we predict that to be one of the most time-consuming steps of this process. The next thing we want you to do is we want you to consider project selection. There are projects being prioritized. Some are already fully capitalized. We want you to look at things that may have a strong job cushion. Specifically, rural projects, they are currently processing faster, in our opinion, in observation. Also, one thing to consider is concurrent filing. If you're legally in the US already on H-1B or F-1 visa, you can file concurrently or I-45 because the retrograde is current or up to date. You are able to file concurrently if there is no retrograde. That is why we think that the window is open, but it's closing fast. You can visit our social media. We would love to work with you to see if you have eligibility for your for the EB-5 visa. The other thing that I wanted to mention here is that if you are thinking about this, it's important to connect with an attorney. I think that right now strategy is everything. So we have some great questions that we are going to answer, and I think that will also reveal some more information that many of you have about the EB-5 at this point. So if we could take I think we usually take like a quick 1 or 2 minute break, and we could answer several questions that I know people have about the EB-5 at this point. I see some questions coming in. We've prepared a few things to provide additional information for you.
Thank you, Ms. Smith, for this insightful presentation. We'll now take a brief break of exactly 1 minute and 11 seconds, and please stay tuned as the session will resume shortly.
Are you an extraordinary individual looking to take your talents to the land of opportunities? Welcome to Raju Law, your trusted partner in the pursuit of the American dream. The EB-1 category is designed for individuals with extraordinary ability in sciences, education, arts, business, athletics, or any professions, as well as for outstanding professors, researchers, and multinational executives or managers. This includes individuals with a record of sustained national or international acclaim, and those who have achieved significant achievements in their field. At Raju Law, we specialize in guiding extraordinary individuals through the complex EB-1 application process with ease and efficiency. We will evaluate your unique qualifications and determine your eligibility to secure this highly sought-after immigration preference. We'll highlight your awards, publications, media recognition, and other evidence to establish your extraordinary ability or outstanding researcher status. Contact us today to learn more about how we can assist you in securing your green card through the EB-1 program.
Welcome back, everyone. That was a very informative session on why now is critical window for EB-5 investors and how delaying decisions could impact eligibility and timelines. Ms. Smith, we have compiled a list of frequently asked questions that many people have about today's topic. So would you mind if I go for it?
Sure, thank you.
All right, thank you. Okay, our first question is, you mentioned the program expires in 2027. Why is everyone calling 2026 the critical deadline?
That's a great question. And it is confusing. It's a common misconception. It's very confusing because the program actually runs until 2027. What we are referring to is the statutory safety net that ends in September 30th, 2026. That RIA included a specific clause that provided for statutory protection if you file by September 30th, 2026. And that is separate from the program running through 2027. So for example, if you wait and file in October 2026, it's a gamble. You've filed after that deadline, the statutory deadline. Even though the program is still valid, you are placing a bet on Congress to pass a new law in time for 2027. If they don't, then your application could be frozen for months. It could be frozen for years. And based on what we saw in 2021, we know that Congress may or may not extend that program. It's difficult to predict these things. And because we know that there is a statutory protection, that is why we think that it is a critical deadline, even though the program doesn't statutorily end until 2027. There is that carve out for September 30th of 2026.
All right, thank you. Our next question is, we have heard about a gold card proposal possibly replacing or competing with EB-5. Should investors wait for that?
That is a great question. We have heard a lot about this gold card visa lately. The thing about it is that we currently strongly advise against waiting for this program. And the main reason is because it would require new legislation. This legislation for the EB-5 is currently existing. It's an existing law with a clear track record. We've seen how it is navigated. We have actual statutes in place. Right now, the gold card proposals, they involve higher cost, often with non-refundable donations, whereas with the EB-5, the investment model where you can actually get your capital back it's a lower risk for an investor. And in immigration law, you always file for the benefit that exists today, not one that might exist tomorrow. And it's difficult to say, what the future will exactly hold. At this time, we haven't seen any kind of proposal for what a gold card visa statute would look like, but we know what the EB-5 visa looks like. We know how it operates, and we know what the financial fees are for this at this time. So that's why we, discourage you from waiting, because right now everything is too hypothetical.
That's great. I'm going to the next question. So our next question is, can you clarify the fee reset? Is it guaranteed that fees will go back up in 2026?
Oh, that's a great question. It is virtually guaranteed that the fees will go back up in 2026. We saw that there's a presiding case right now where the fees were temporarily rolled back. And all that means is that the USCIS is likely in Q3 or Q4. They're likely to push for a new rule. The court paused the fee hike because of procedural errors by the USCIS, not because the fees were unjustified. So once that rule, comes out, we expect it in Q3, Q4 of 2026. And once that rule comes out, the filing fee for the I-526E will likely jump back up to where it was, well over $11,000. Filing now is an easy way to save roughly $7,000 to $8,000 in governmental fees and associated with that application.
All right, thank you very much, Ms. Mapes. Okay, I'm going to the next question. Our next question is, for investors from India or China, is the rural category still the best option in 2026?
Yes, I absolutely think it can be, because rural projects continue to receive two massive benefits from the USCIS filings that we have seen. They get what we refer to as priority processing. We are seeing approvals within 12 months, sometimes less. And this is in comparison to 3 to 4 years for standard cases. The second benefit is these concept of visa set-asides. I mentioned this in my slides that there is a high unemployment urban category. However, it's getting more crowded, it's more popular, they're seeing more applicants. So the risk for backlog is real. And the rural category has a much larger supply of visas, potentially up to 20% of the total. And it currently is the safest lane to avoid retrogression for at least another year.
All right, thank you very much. Our next question is, if I'm currently in the US on an H-1B visa, how does the 2026 deadline affect me specifically?
This is a great question. Many of you may be strategizing what your next steps for your visa will be. And so this could be very relevant for many of you. For H-1B visa holders, the urgency is even higher due to the benefit of concurrent filing. Right now, you can file for your green card application, the I-485, alongside your EB-5 petition. This is what we refer to as concurrent filing when you submit both. This will give you an EAD work permit, also advanced parole for your traveling, and about 3 to 6 months. It gets you in about 3 to 6 months, which ultimately frees you from H-1B employer dependence. However, I'll mention also that if retrogression hits later this year, because so many start filing for the EB-5, you will lose that ability to file concurrently. It is only available if the USCIS petition is board is up to date, right? That is another reason to get your application in early, while the visa bulletin still says that it is in current status.
All right, thank you very much, Smith.
Yep.
Okay, the next very frequent asked question is, what is the realistic last call date to start the process if I want to meet the September 30th, 2026 deadline?
Yeah, that's such a great question. In all reality, these petitions or applications do take some time to put together. So we do not want you to wait until September thinking that 30 days will be sufficient for putting together a petition that is likely to be approved. We would ideally prefer to start by April or May. This would give us plenty of time to do the various steps that are necessary, put together the strongest case, the best evidence. However, what we call the drop dead date, if you haven't hired an immigration attorney to a project by, say, middle of July 2026, it will be extremely stressful and risky to try to file a quality petition by September 30th. So for us, our recommendation is to start working with an immigration attorney by April or May. The EB-5 is not something you can just sign up for. We need to prove where every dollar of your $800,000, comes from, and that process does take quite a bit of time. It does require very specific evidence, and we like to work closely with our clients to make sure that we put together the best case possible. So that does require some time. Plus, ultimately, we believe that the fear of retrogression or the idea of retrogression is very likely. So earlier the better, honestly.
All right, that was amazing. Thank you, Ms. Smith. Pretty much all about it. Just what would be your suggestion, next step for the audience?
This is a great question to end on. I think if I were in this audience, my recommendation to any of you who may be considering the EB-5 visa, I wouldn't want you to guess about your eligibility today. We did not discuss eligibility. We talked about this timeline, this concept of filing, and some broad concepts of what a case could look like, but we didn't get into eligibility. That is a very personal question, and it's very case specific. So what our firm is doing is we are offering a free source of funds preliminary review to anybody who thinks that they may be eligible for the EB-5 visa. For anybody who is watching this session who contacts us this week, you will get if you want to reach out to us, we will take a look at your assets and tell you if you can be ready by the September deadline. Again, that is through our free source of funds preliminary review. The source of funds tends to be pretty where we spend most of our time in the EB-5 developmental aspects. So this will be a great opportunity for anybody who wants to engage with our law firm to learn more about their specific eligibility and what we could do by that September deadline. And I will add our contact information up here one more time. Just to have that there for you. But as always, you can reach out to us through our email, info@rajulaw.com. We have a website with wonderful resources. If there's any of you who are interested in the EB-5, we would love to help take a look at your case-specific information and see if we could help you meet that deadline.
All right. Thank you, Ms. Smith, for explaining these complex issues so clearly. I'm sure our audience finds this guidance extremely helpful. Okay. Before we wrap up, Ms. Smith, do you have any final advice for the investors who are considering EB-5 and are unsure whether they should act now or wait?
My closing thoughts on this are just that I love the concept of statutory protection. When things are clearly stated, then that creates less gray area for processing. And we know that the USCIS has their adjudication responsibilities. But when they have clear statutory obligations, then we get more clarity and more guidance from exactly how these cases should play out. And I think that should be reassuring and something that a lot of people could find comfort in during times when we think that there may be inconsistencies or just general difficulties in the immigration process as a whole. So that would be my biggest thing, that as an attorney, I find a lot of comfort with statutory protections, and we would be eager to connect with you to see if your portfolio matches for that, for an EB-5 visa. That could be a great pathway forward during 2026.
All right, wonderful. Thank you so much, Ms. Smith, for joining us today and sharing your valuable insights. It is always a pleasure having you with us.
Thank you for having me. I hope you all are doing well. Have a great day.
You too. Thank you. Thank you very much.
Thank you.
All right. So that brings us to the final segment of today's session, our weekly immigration news update. Thank you to everyone who stayed with us till the end. Before we close, let's take a quick look at the most important immigration updates from this week that you should be aware of. Until next time, this is Ms. Faral Dushari signing off. Stay informed and stay ahead. Have a great day.
Hi everyone, welcome to this week's immigration update from Raju Law. We bring you the latest news, USCIS updates, and policy changes that matter. This week's top stories include: ICE launches new crackdown in Maine. Child detained in Minneapolis immigration arrest sparks outrage. Nationwide protests against Trump immigration policies. EB-1A Einstein visa filings surge. ICE memo raises concerns over home entry without judicial warrants. Judge allows DHS to limit lawmakers' ICE inspections. Let's begin with new ICE enforcement activity. The Trump administration has launched a new ICE operation in Maine called Operation Catch of the Day. DHS confirmed raids began this week, raising concern among immigrant communities, especially Somali Americans. Local leaders warned the operation has created fear and urged ICE to avoid aggressive tactics used in recent enforcement actions elsewhere. Next, a case that sparked national outrage. Federal agents detained a 5-year-old boy and his father in Minnesota, drawing backlash after a photo showed the child in custody with a Spider-Man backpack. The family are asylum seekers from Ecuador with active cases. Authorities say the arrest followed legal procedures, while attorneys dispute the government's account. Now, public reaction across the country. Thousands of people protested across major U.S. cities and college campuses against President Trump's immigration policies. Demonstrators criticized ICE enforcement tactics and recent detention-related deaths. The protests come amid growing opposition to aggressive deportation efforts nationwide. Next, a shift in legal immigration strategy. Applications for the EB-1A Extraordinary Ability Green Card have tripled over the past 4 years. Highly skilled workers are increasingly using this route to avoid the H-1B lottery and long green card backlogs, especially for applicants from India and China. Now, a controversial internal ICE memo. An internal ICE memo revealed that officers may enter homes using administrative warrants without approval from a judge in cases involving final removal orders. The guidance has raised serious legal and civil rights concerns, with critics warning it weakens constitutional protections. And finally, a key court ruling. A federal judge has allowed DHS to require members of Congress to give 7 days' notice before inspecting immigration detention facilities. Lawmakers argue the rule limits oversight, while DHS says it is necessary for security and coordination. That wraps up this week's immigration updates. Stay connected with Raju Law for more news, insights, and guidance. See you next week with the latest developments in U.S. immigration.